I think you're presiding, right? Okay, so we're all scoring. All right.
Good morning, everybody. Everybody is free to sit down. Before we get started, I just want to make sure that all of our jurors are able to access your ballots. And by all of our jurors, I also mean myself. Everybody good? You got your ballots up? Great. Okay, and also jurors, could you take a look at the competitors and witnesses and make sure that you're not related to any of them or didn't go to school with any of them? And we'll know which trial we're scoring in just a moment after they make appearances, because I think the which trial is just basically their last names. So we'll know that in just a second when we do appearances. Good morning. Calling the case of Peter Jones versus Dragon Studios, case number 2024. My name is John Bishop. I've been assigned to hear the matter. We are in front of a jury and will be constructively always in front of a jury so that they can put check marks on a piece of paper about your performance. Before we do anything else, may I have appearances from both sides, starting with the estate of Mr. Jones?
Yes, Your Honor. Good morning. My name is Everett Parker-Noblitt, along with my co-counsel, Mr. Veglahn.
Good morning, Your Honor.
Good morning. And do you go by Mr. Noblitt?
Parker-Noblitt.
Parker-Noblitt, sorry. Okay. So, jurors, this trial is Parker-Noblitt versus the last selection. Parker-Noblitt v. and what's your last name?
Veglahn. Your Honor.
Parker-Noblitt v. Veglahn is the choice for the trial that we're scoring. Go ahead, sir.
And Your Honor, collectively, Mr. McLaughlin and I represent the estate of Peter Jones. Would you like to hear appearances from the defense?
I would.
Good morning, Your Honor. My name is Margaret Veglahn, and I'm joined here in court today by my co-counsel, Mr. Ian Carson.
Good morning.
Together, we represent the defendant in today's case, Dragon Studios.
Good morning. Is it Ms. Veglahn?
Yes, Your Honor.
Okay, so Mr. Parker-Noblitt and Ms. Veglahn. Okay. Before we hear opening statements, does either side have anything they'd like to talk about in terms of pretrial or housekeeping, starting with the estate of Mr. Jones, Mr. Parker-Noblitt?
Yes, Your Honor. First, we'd just like to note evidentiary ruling 6 that was made before trial. It says exhibits 1 through 25 in today's case have been pre-admitted, and we're allowed to reference them during opening statements.
You are allowed to reference them during opening statements, and for the record, exhibits 1 through 25 are admitted.
Yes, Your Honor. And Your Honor, we'd also like to invoke Midland's Rules of Evidence, California Rules of Evidence 603 and 615, which call for the constructive swearing in and sequestration of all witnesses, barring party representatives. The estate of Peter Jones has no party.
Okay. Ms. Veglahn, do you have any objection to the invocation of the rules cited by opposing counsel?
No objection, Your Honor, and the defense does not have a party representative either.
Okay, then all witnesses in this trial have already been sworn in and will tell the truth, and all witnesses in this trial are not in the room even when it seems like they are.
Yes, Your Honor. And Your Honor, with that, the plaintiff's ready to proceed.
Okay, Ms. Veglahn, any pretrial matters you'd like to talk about or housekeeping?
Yes, Your Honor, just two housekeeping matters from us. First, we'd like to note that verdict form F will be operative during today's trial, which says that the defense has already agreed to and admitted to the plaintiff's claim of negligence, but is raising an affirmative defense of the assumption of risk.
Okay.
And finally, we'd just like to ask your preferences when it comes to movement about the well. Would you like us to ask permission to approach opposing counsel, the witness, and Your Honor, or just state it for the record?
You may move freely about the well during opening and closing statements. When you are conducting your examinations, you should ask permission before approaching the witness, the jury, or the bench.
Understood, Your Honor. With that, the defense is ready for trial.
Okay, in that case, we'll move right to opening statements, beginning with the estate of Mr. Jones. Mr. Parker-Noblitt, when you're ready.
Yes, Your Honor. Your Honor. Ms. Veglahn. Members of the jury. He waited for a word that never came. Peter Jones is fallen. And he's falling fast. You see, Peter Jones has just driven a motorcycle off a cliff. Every second that passes, he's going closer and closer to the ground. But he's not worried. He's waiting. He's got an earpiece in his ear, a parachute on his back, all waiting for one word from his director. Pull. One word, and Peter Jones would pull the parachute on his back and fly to safety. So he waits. 5 seconds. 9 seconds. 15. That word never comes. Peter Jones hits the ground before his parachute deploys at 120 miles per hour. He dies. He dies waiting for a word that never came. We all know Peter Jones. We probably all remember where we were when he died. For the past decade and a half, Peter Jones has been the biggest actor on the planet. When we saw him up there on that big screen, Peter Jones was like a god, pulling off impossible stunt after impossible stunt. He made us all believe in the impossible. You see, that made it all too easy to forget. Peter Jones was a real person, just like you or me. He was human. And to pull off all those stunts you saw on those big screens, he had to have people behind him. People to trust. And on that day, Peter Jones put his trust in this company, the owner and the director of that film. He put his trust in one man to say one word: pull. But we're here because that director broke that trust. And Peter Jones died, waiting for a word that never came. So why are we here? Well, today you're actually going to learn that we're not here to determine whether or not a risk caused Peter Jones's death. We know it did. In fact, the defendant's company has already acknowledged their negligence. Their unreasonable actions are what caused Peter Jones's death. You see, as the plaintiff in today's case, we're not going to bear the burden of proof. It's going to be the defense. Because they're going to try and prove to you today that Peter Jones assumed the risk that caused his death. And throughout today's trial, members of the jury, I'm going to ask you to hold them to that and ask them to be specific. What risk caused that death? Because you're not going to hear evidence of a parachute malfunction or a drone colliding with Mr. Jones. No, you're going to hear that Mr. Jones fell and never even tried to pull that parachute. And members of the jury, the law is clear. If someone has a risk they don't know about, then you have to find that company liable. And we'll show that to you today. Because Peter Jones died waiting for a word that never came. And we'll show that, showing 3 facts to you today that show Peter Jones could never have assumed that risk. First, Peter Jones trusted his director to say that word. Pull. We actually expect that director will take this stand today and admit that to you. He was obligated contractually to say that word. And that takes us to fact 2. He didn't. you're going to learn that word never came when we call Peter Jones's agent, Miss Veglahn. She'll tell you she was feet away from that director, waiting for him to say that word, waiting as those seconds passed, but it was too late. You'll learn the director said why he waited. He just wanted a longer shot. And that brings us to the last fact. That failure by that director is what caused Peter Jones's death. Members of the jury, you're going to see that Peter Jones did that stunt time and time again, 6 times the day before. Every time he got the word, he pulled. But this time was different. He never got that word. And he died. He died waiting for a word that never came. And members of the jury, you can't assume a risk you don't know about. Which is why at the end of trial, I'll ask that you find Dragon Studios live. Thank you for your time.
Thank you, counsel. Ms. Veglahn, would you like to give your opening statement at this time?
Yes, Your Honor.
Please do.
Mr. Parker-Noblitt, members of the jury, may it please the court. When Peter Jones jumped, he knew he could fall. It's June 20th, 2023. Peter Jones is at dinner. He's just finished a day of filming his newest movie, and it has his biggest stunt yet. 6 times that day, he drove a motorcycle off of a 2,700-foot cliff, let go in midair, and parachuted down to the ground. It went well. Peter Jones is enjoying his meal. When the director of that movie, a man named Cole Doig, comes to Peter with an idea. Let's shoot the stunt again tomorrow. But this time, instead of having you wait 4 seconds to open your parachute, let's have you wait 9 seconds instead. Now, an extra 5 seconds, members of the jury, that might not sound like a lot to you or I. But to an experienced skydiver, 5 extra seconds of free fall is an eternity. It's enough to turn a safe, standard jump into a big risk. But here's what Mr. Parker-Noblitt left out of his opening statement. Peter Jones agreed to change that stunt. Today, the evidence is going to show that Mr. Jones knew that it was riskier. He knew that it was more dangerous. But he said yes. When Peter Jones jumped, he knew he could fall. And that changes everything. Folks, we agree with the plaintiff. The stunt that was attempted that next day was absolutely not safe. We agree. Dragon Studios never should have changed that plan. In fact, our client admits that it was their actions changing that stunt plan that caused Mr. Jones's death. But there's a reason we're still here in court. Because the law tells us that if Mr. Jones understood that risk, if he knew not that this would happen, but just that it could, then it doesn't matter what Dragon Studios did. You can't find for the plaintiff. When we raised that affirmative defense of the assumption of risk, we took on a burden to prove it to you. We have to show you by a preponderance of the evidence just that it's more likely than not that Peter Jones understood the risk he was taking and chose to take that risk anyway. It's a burden we're going to meet today. To show you how, I'm going to ask you to focus on 3 simple facts. The 9-second jump was dangerous. Peter Jones knew it was dangerous, and he did it anyway. So first, the revised version of that stunt, the 9-second jump, was dangerous. Today, you're going to learn that there's an industry standard in skydiving. Divers are supposed to have their parachutes completely open by the time they're 2,000 feet above the ground. That's because it gives them a margin for error, time to adjust, to pull a backup chute, to change tack if something goes wrong. So any jump that opens a parachute below that industry standard, that gets rid of that margin for error. Fact number 2, Peter Jones knew that. Today you're going to learn that Mr. Jones was an experienced action movie star, an experienced skydiver. The evidence is going to show that he signed off on the fact that his jump was only safe if it was above 2,000 feet. Fact number 3, when the plan changed, he did it anyway. Whether Mr. Jones was never given a word or just never received it, whether there was some technical malfunction or he just couldn't reach the cord, one thing today will be clear. It was Mr. Jones's decision. Everyone's decision, but Mr. Jones's decision too, to change that plan that eliminated his margin for error. It was his decision to take that risk that caused his death. When Peter Jones jumped, he knew that he could fall. That's why at the end of this trial, I'm going to come before you again and ask you to find the defendant not liable. Thank you.
Thank you, counsel. Mr. Parker-Noblitt, would you like to call your first witness?
Yes, Your Honor. The plaintiff calls Eli Gogian.
Okay. Ms. Gogian, you could step forward. Pursuant to the court's order, the witness has already been sworn in, so Mr. Parker-Noblitt, you may proceed when you're ready.
Yes, Your Honor. Good morning.
Good morning.
Could you go ahead and introduce yourself to the court?
Good morning, everyone. My name is Eli Gogian. I'm a talent agent. I was Peter Jones' talent agent throughout all of his movies.
How long have you been a talent agent?
Really, it's my only career. I've been Peter Jones' talent agent throughout the entire All Lost series franchise, so that was a total of 6 movies, and we were going to film a 7th.
Ma'am, you mentioned the All Lost movie series. Could you tell us what that was?
The All Lost movie series was an action movie franchise. Think of a classic Tom Cruise action movie, and Peter Jones was the star of all of those movies.
For those movies, did Peter Jones work with a studio?
Yes, it was Dragon Studios.
Ma'am, I'd like to give the jury some background on what making those movies entailed, okay? Now, ma'am, how did you go about the plan for those movies?
There were 3 main people that worked on those movies. It was Peter, he was the star, me as his talent agent, and then the director and producer of the movies, Cole Doig. The 3 of us would work together on all of the plans, including plans for any stunts that Peter would be doing in those films.
What stunt was planned for that last movie?
For the last movie that we were going to film, Peter's stunt involved driving a motorcycle off of a cliff, and then he was supposed to be able to parachute down safely.
And he said he was supposed to be able to parachute safely. I want to break that down. Who did he talk to about that?
Me as his talent agent, but it was the producer and director, Cole Doig, that brought in a safety coordinator, a stunt coordinator, and it was them that worked on the plan to figure out how to pull the parachute safely.
Objection, Your Honor. Lacks foundation. May I be heard?
Not yet. Do you have a response?
Yes, Your Honor. I believe this witness has already laid that foundation. She's discussing what was said in a conversation with her, Peter Jones, and Ms. Doig. This is just what Mr. Doig said.
Now you may be heard.
Yes, Your Honor. This witness has established that she was Mr. Jones's agent, but she hasn't established that she was involved in all of these meetings. All she said are the people who planned that stunt, but she hasn't actually laid the foundation as to how she would know that. Her being Mr. Jones's talent agent alone, that's not enough foundation.
Response, Your Honor?
Sure.
Your Honor, that's not the only foundation on the record. I asked Ms. Veglahn whether or not there was a plan in place and whether or not she spoke about it with Mr. Jones and Cole Doig. I believe this witness has laid appropriate foundation to testify.
Okay, I think the question as posed did in fact lack foundation, but I think the answer ended up laying the foundation. And so I understand your concern, but I think, I don't know how she would have known that based on the question that was asked. Who did he talk about this with? Because it's somebody else. But then she explained, and she ended up saying the things that he just not exactly proffered, but just explained to the court. So the objection is overruled, but if there are further concerns about foundation, probably the time to raise them is in the form of the question.
Yes, Your Honor.
Yes, Your Honor.
Go ahead.
Ma'am, you were talking about a conversation you had with that director. What did that director say the plan was?
Initially, the plan for the stunt was that the director was going to be the one to give Peter Jones the signal to pull the parachute. The original plan was that he'd give that signal after 4 seconds of free fall.
Ma'am, if Peter Jones was jumping off a cliff, how would he get that signal?
Peter was going to be wearing an earpiece. On the other end of that earpiece was the producer, Cole Doig. Cole would give Peter the signal when he was supposed to pull the parachute.
Ma'am, when was that stunt supposed to take place?
We were practicing the stunt on June 20th of last year, and the plan was to practice it a total of 6 times.
I'd like to talk about those 6 times. What day was that?
It was June 20th, last year.
What happened during those 6 stunts?
Each of the 6 times we followed the plan like I thought we were going to. Peter would jump off the cliff, and 4 seconds after the free fall, Cole gave him the signal to pull.
Now, ma'am, each time that signal was given, did Peter Jones pull his parachute?
Yes. Right after Cole gave the signal, Peter would pull instantly.
What happened after you finished filming?
I thought everything went great. We just pulled off this stunt 6 times safely, so we had a celebratory dinner. But that's when Cole proposed a new idea.
What new idea?
Cole said that the scene wasn't long enough and he wanted more film. So he proposed doing the stunt a 7th time the next day. But for longer.
How long?
He proposed that Peter would fall for 9 seconds instead of 4 like we'd done the day before.
Ma'am, did Cole Doig tell you and Peter Jones how he'd know if 9 seconds had passed?
No, not specifically.
Well, ma'am, did he say if he'd followed the plan from before outside of that 9-second change?
He said the only thing that would change would be the 9 seconds. We'd do what we did the day before, but instead of 4 seconds, Peter would fall for 9.
Well, ma'am, let's talk about what happened on June 21st. Where were you that day?
I was in the control room with Cole during the stunt. I was just a few feet away from Cole.
What was Cole doing?
Cole had the walkie-talkie in his hand. That was what was going to connect to the earpiece Peter was wearing. So we started the stunt like normal.
What happened when Peter drove that motorcycle down that ramp?
We could see him in the control room, so we watched as Peter drove the motorcycle down the ramp, and then he started that free fall. I was waiting as the seconds passed, and I thought at 9 seconds Cole would give the signal.
What happened at 9 seconds?
Well, I looked at...
Objection, Your Honor. Lacks foundation. May I be heard?
Yes.
Your Honor, we've heard absolutely no foundation as to how this witness would know exactly 9 seconds had passed. We haven't heard if there was a clock in the room, if she was wearing a watch, if she was just counting herself. This entire trial is about what happened at 9 seconds. It's very important to understand how this witness knew that 9 seconds had passed.
Response, Your Honor?
Sure.
Your Honor, I believe this witness stated that she was watching the seconds tick down on the screen I'd be happy to lay that foundation more clearly.
You don't need to. The objection's overruled.
Yes, Your Honor.
Yes, Your Honor.
I was watching Peter as he was falling, and I could see the seconds tick by. So at 9 seconds, I thought Cole was going to give the signal, but he just stood there. He didn't say anything.
What happened after 9 seconds passed?
Well, I said to Cole, I asked him, why aren't you giving the signal? And he just put his hand up. He didn't give the signal.
The record will reflect the witness raised her left hand. Go
Yes,
ahead.
Your Honor.
Go ahead, counsel.
Now, ma'am, after Cole Doig put his hand up, what did you do?
I mean, I just asked again, why aren't you giving him the signal? But Cole didn't say anything. Cole never gave Peter the signal to pull his parachute.
Ms. Veglahn, did you see what happened after that signal wasn't given?
Peter just kept falling and falling, and we could see it on the screen. He didn't pull his parachute in time, so he hit the ground. He was dead.
And we're going to have to talk about what happened after Peter hit the ground there. Did you go down to check?
Cole and I and the rest of the crew, we went down to where Peter had landed. I just couldn't believe what happened. I asked Cole, why didn't you pull at 9 seconds? Why didn't you give the signal?
What did he say?
Cole just said he wanted the scene to be longer.
Thank you, ma'am. Your Honor, I have nothing further.
Okay, thank you, counsel. Cross-examination?
Yes, Your Honor. Good morning, ma'am.
Good morning.
I want to start by talking about the plan for that stunt that you were mentioning on direct, okay?
Okay.
Because there was actually a written version of that stunt plan, right?
Yes, we drafted up a plan. It was in writing.
You signed that plan, right?
Yes,
Peter Jones signed that plan.
he did.
You'd recognize a copy of it if you saw it, true?
I would.
If you could flip in that binder in front of you to Exhibit 34 and just let me know when you're there.
I'm there.
Ma'am, this is a copy of that plan, right?
Yes, it looks to be.
It's fair and accurate.
Yes.
And there at the bottom, you see Peter Jones's signature, true?
Yes, he signed this plan.
We move Exhibit 34 into evidence.
Any objection?
Without objection.
34 is admitted.
Ma'am, the last bullet point on this plan says that the industry standard safe limit for skydivers is to open their parachute by the time they are 2,000 feet above the ground, right?
Yes, that's what it says.
Let's talk about exactly what that means. Because this plan, it also mentions some calculations that were done by your stunt coordinator, right?
Yes, it does.
They're called the body in free fall calculations, right?
Yes, that basically calculated how long we could wait before Peter needed to get the signal to pull.
Right, ma'am, and in this plan, it says this precaution is based on the body in free fall calculations, which are fully incorporated into this stunt plan and agreed to by all parties to this stunt plan, right?
Yes.
One of those parties who agreed, that was Peter Jones.
Yes, he signed this.
Let's talk about what those calculations said. If you could turn to Exhibit 15 for me. Your Honor, this is already in evidence. Permission at this time for Mr. Carson to tender some copies of Exhibit 15 to the members of the jury.
He may.
So ma'am, this document, Exhibit 15, those are those calculations done by that stunt coordinator, right?
Yes.
I know there's a lot of information here, but I want to focus on this chart in the top left. This chart calculated how many feet above the ground Peter Jones would be per second if he didn't have a parachute, right?
Yes.
So just to be clear, that means at 0 seconds, he was at 2,701 feet.
Yes.
It was calculated that by 19 seconds of free fall, he'd hit the ground, right?
Yes.
So let's talk about the original plan for that jump, the 4-second one. Because, ma'am, we can agree, the cliff that Peter Jones was jumping off of, that was 2,701 feet in the air.
Yes, that's how high it was.
In the original plan, it took him 4 seconds to pull the cord, right?
In the original plan, Cole would give the signal after 4 seconds of free fall. So it would take about 5-6 seconds before he'd pull the parachute.
Ma'am, the plan was for him to pull the cord as close to 4 seconds as possible, right?
Yes.
And according to that stunt plan, it takes another 3 seconds for the parachute to open all the way.
That's right.
You'll bear with me here, I want to do just a little bit of math. 4 seconds plus 3 seconds. These calculations say that in the original plan, Peter Jones' parachute would be fully open when he was 2,049 feet above the ground.
Yes, that's right.
Ma'am, in the original plan, Peter Jones was opening his parachute just 49 feet above that industry standard safe minimum, right?
Yes.
So let's talk about the 9-second version. Because, ma'am, in the 9-second version of the stunt, he was still starting from 2,700 feet, right?
Yes.
But this time, he would wait 9 whole seconds to even pull that cord. True?
Yes.
Once again, 3 more seconds for it to inflate.
Yes.
9 seconds plus 3 seconds, ma'am, in the new version of the plan, Peter Jones's parachute would only be open 1,218 feet above the ground.
Yes, that's right.
In the new version of the plan, Peter Jones would be inflating his parachute 800 feet below that safe standard minimum. True?
In the new plan, that was what was going to happen, but he never got the signal at 9 seconds, so that's not what happened.
Ma'am, that was a yes. In the new version of the plan, he would be opening his parachute 800 feet below the industry standard, right?
That's how high he would be, yes.
These calculations, all those numbers, were included in the stunt plan that Peter Jones signed off on.
Yes, he had access to this.
Ma'am, Cole Doig came to you and Peter Jones the night before you did that last stunt, right?
Yes, we had a conversation at the dinner I mentioned earlier.
Mr. Doig said, I want to change the plan from 4 seconds to 9, right?
Yes.
Even though that deviated from the original stunt plan, Mr. Jones agreed. True?
He was hesitant at first, but yes, he agreed.
Even though it deviated from the plan he had practiced, Mr. Jones agreed.
Yes.
Even though it deviated from the plan he had successfully performed, Mr. Jones agreed, right?
He agreed to get the signal at 9 seconds, but Cole never gave that signal.
Ma'am, even though that 9-second plan would have Mr. Jones opening his parachute below the industry standard safe minimum, Mr. Jones agreed to jump. Right?
He agreed to that.
Thank you, ma'am. I have nothing further.
Thank you, counsel. Mr. Parker-Noblitt, redirect.
Yes, Your Honor. With the court's permission. Ms. Gogian, I'd like to talk a little bit about the plan Ms. Veglahn just talked to you about, okay?
Okay.
Because Cole Doig, was he the one that pitched you that 9-second plan?
The 9 seconds was all Cole's idea, yes.
Ma'am, did he tell you and Peter whether or not he got that plan approved?
He told us that he had talked to the stunt coordinator, and the stunt coordinator said 9 seconds was doable. That's what Cole said.
Well, then, ma'am, I'd like to talk about that stunt plan that was signed. Ms. Veglahn talked about the bottom paragraph here. Does this tell us who was supposed to give that order to pull?
No, not specifically, but It was supposed to be Cole on the day of the accident.
Ma'am, right here, the second sentence, what does it say?
Which exhibit is this, sir?
Exhibit 34, ma'am.
It explains that the two options were either Sky, that was the stunt coordinator, or Cole, that would be giving the signal. On the day of the accident, it was going to be Cole.
On the day of the accident, was Sky Stebbins there?
No, Sky wasn't there.
Ma'am, who signed this stunt plan, saying someone would tell them to pull?
Peter.
Anyone else?
All of us. Cole. He agreed to give the signal.
Thank you, ma'am. Your Honor, I have nothing further.
All right, recross.
No recross, Your Honor.
All right, thank you, Ms. Veglahn, for your testimony. You're excused. Does the plaintiff have any further witnesses to call?
No, Your Honor, the plaintiff rests his case in chief.
Okay, defense, are you ready to call the first witness?
Yes, Your Honor, the defense calls Cole Doig.
All right, Mr. Doig. Have a seat, sir. Pursuant to the court's pretrial order, you've already been sworn in.
Yes, sir.
So, Ms. Veglahn, when you're ready.
Yes, Your Honor. Good morning.
Good morning.
Could you please introduce yourself to the members of the jury?
Of course. Morning. My name is Cole Doig.
What do you do for a living?
I'm the proud president, founder of Dragon Studios. It's down the block from here.
Sir, did you know someone named Peter Jones?
I did. Peter was one of our actors over at the studio.
What was your relationship with Mr. Jones like?
Well, I didn't just work with him. I considered him to be a really good friend of mine. I cared about him.
So, sir, I want to talk a little bit about this case. Were you involved with a cliff jumping stunt that Peter Jones was doing?
I was. I was the director of the recent movie they were filming, All Lost 7. It's where I was doing the stunt.
Had you ever directed a movie with stunts in it before?
Of course. Our studio's known for big action movies, blockbusters. The All Lost series was known for their stunts.
You said that this was the 7th movie in that series. Was Peter Jones in all of them?
He was the star.
So let's talk a bit about this specific stunt. Could you walk the members of the jury through how it was supposed to work?
Of course. The stunt begins with him on the side of a mountain. He's riding a motorcycle. Goes down a ramp, off to the air, lets go. Free falls for a couple of seconds and then parachutes into a nearby field.
You mentioned free falling. In your original plan, how long was Mr. Jones supposed to be free falling?
Well, when we planned it at first, he was falling for about 4 seconds off the ramp.
Did you ever run that 4-second version of the stunt?
We did. About 6 times on the first day of filming. It was mid to late June of last year.
I want to talk about if that stunt ever changed. Did you have a conversation with Mr. Jones after filming those first 6 takes?
Yeah, we did. It was dinner with the cast and crew. Pulled him aside and talked about whether or not we wanted to change it.
What did you tell him?
I told him that I thought the scene could be a bit longer. It felt a little bit short at first, so we told him we were going to move the stunt and do it again in the morning.
Did you tell Mr. Jones how you wanted to change that stunt?
Told him instead of waiting at 4 seconds, we were going to do 9 seconds instead. I told him that at 9 seconds off the ramp, I would give him the signal and he'd pull the parachute then.
I want to talk about whether waiting 9 seconds was dangerous. Sir, if you could open that binder in front of you to Exhibit 34. Your Honor, this is already in evidence. Permission to publish a copy of Exhibit 34 to the members of the jury at this time?
You may.
I'm there.
Sir, does this document say anything about industry standards for a safe jump?
Yes, ma'am. We wrote this about a year before filming. The last section here, it tells us that the skydiving industry standards, a diver's supposed to open their parachute, have it fully inflated before they reach about 2,000 feet.
Did Peter Jones sign this document?
He did.
Was Peter Jones involved in writing this document?
Yes, ma'am. Me, Peter, Eli, his agent, and our stunt coordinator, the four of us met to write this.
So let's talk about how that 9-second version of the stunt went. Sir, you told us that you've directed a lot of movies with stunts. Do you know why skydivers are supposed to open their parachute at a certain point?
Yes, ma'am. It's a safety concern. We need the skydiver to have enough time to fix any problems that might have. It's about a margin of
Objection,
error.
Your Honor. Pursuant to Rule 702, may I be heard?
Can you state the grounds of your objection using something other than the rule number? Because
Yes, Your Honor, this is an improper opinion. May I be heard on those grounds?
Got it. Yes, briefly.
Your Honor, this witness is testifying about a number of things in the field of parachuting and skydiving, and whether or not all these things need to happen in order to make it safe. There's been no foundation on the record he has any expertise in skydiving that would allow him to make that opinion.
May I respond?
You may.
Your Honor, this witness is not making a conclusion. He's already testified that he's directed lots of movies with stunts before, and that he was involved in planning this particular stunt. It's certainly within his rationally based perception to say that opening in a parachute at a certain time is a safety concern, so skydivers can do a safe jump. That's not an expert conclusion.
Okay, I agree with you. I think he said that. And so I'm gonna overrule the objection, but I'm gonna instruct the witness to conclude his answer at the point of the objection. Because I do think that his testimony to this point is based on common sense, as you articulated. But I don't know exactly where he's going, and your question was fairly broad. So your objection's overruled, but your concerns are noted. As such, I'm going to instruct the witness to end his answer, and if follow-up questions intrude into something more technical, you can re-raise the objection.
Yes, Your Honor.
Sir, just for the record, could you tell us why there's a certain time when a skydiver needs to open their parachute?
Of course, when we film stunts like these, we want to be able to give our actors, the performers doing the stunts themselves, time to fix any problems that might happen. We just want to make sure they're safe.
So, sir, on the day of the stunt, when you planned to give Mr. Jones the signal at 9 seconds, did you do that?
I gave Peter Jones the signal at 9 seconds.
Did he open his parachute at 9 seconds?
No. I kept yelling, screaming, pull, 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 and he didn't do it. It wasn't until about 14 seconds that we saw him pull the full parachute.
Do you know why Peter Jones didn't open that parachute?
I have no idea what happened. I don't know if the earpiece wasn't working or if he was just waiting. Only thing I know is that it was too late.
Thank you for your time, sir. I have nothing further.
Thank you, counsel. Cross-exam.
Yes, Your Honor. With the court's permission.
Go ahead.
Good morning, Mr. Doig.
Morning, sir.
I want to start by clearing a few facts up for the members of the jury, okay?
Okay.
Because you and Miss Veglahn talked about a change in plans, right?
That's right, when we changed the plan from 4 seconds to 9 seconds at cast dinner.
That's right. Before June 21st, you changed the plan from 4 seconds to 9 seconds before giving the word.
That's right.
Let's talk about why you did that. 'Cause, sir, you actually got a lot of film on June 20th, right?
We did. 6 takes.
You filmed 6 takes, and you had a complete shot, right?
We did.
But you, sir, you didn't like it, did you?
I felt as if the scene was a little bit too short. Thought we could get a little bit more.
That's right. You thought that fall from that cliff, it was insubstantial, right?
Not the fall from the cliff, it was more of the free fall to the ground.
You would say it didn't look dangerous enough, right?
I thought the audience would have expected something bigger from our 7th film. Yes, sir.
That wasn't my question. You thought it didn't look dangerous enough. That's what you thought.
Sure.
Let's talk about what you communicated to Peter Jones. Because, sir, you didn't just change the plan and go ahead with it, did you?
No, I spoke to a couple of people about it.
That's right, you talked to a stunt professional, didn't you?
Yes, I wanted to make sure that we were doing things right.
That's right. You talked to Sky Stebbins, the stunt professional you hired to be on set.
I did.
You had a conversation about changing that plan,
I did.
and you then communicated that information to Peter Jones.
Yes, what Sky told me, I told Peter Jones and his agent.
Well, sir, you told Peter Jones you'd gotten the okay, right?
That's right.
You told Peter Jones that Sky had told him that stunt was safe, right?
Right. Ms. Stebbins told me that doing it about 1,000 feet, that would be perfectly fine.
That's right. Let's look at these calculations, sir. Right here on Exhibit 15, about 13 seconds. That's 1,000 feet, right? 30, yes, my apologies, sir, 15.
You said 1,000 feet?
Yes, sir, 1,000 feet. It's about 13 seconds on this graph, right?
Yes, sir, give or take.
Takes 3 seconds to open that parachute.
That's right.
So actually, at 10 seconds, Miss Stebbins said that would be fine, right?
That's right.
You said the industry standard was conservative, right?
Yeah, the industry standard we agreed to was to do it above 2,000 feet, but when a skydiver has experience, they have a little bit more wiggle room to be able to fall.
Now, sir, I want to make clear who this information was communicated to. Now, that information about the 1,000 feet being safe, you told that to Peter Jones.
I did.
Peter Jones then agreed to go forward with that stunt.
That's right. Me, Eli, and Peter talked about the stunt, agreed, showed up the next day to film it.
He agreed to that stunt after you told him a stunt coordinator said it was fine.
He did.
He agreed to that stunt after you told him you'd tell him to pull.
That's right.
Well, sir, I actually want you to turn in that binder to Exhibit 35, okay?
I'm there.
Stunt plan. Now, sir, it wasn't just that word that you said you'd tell him to pull, right?
That's right.
You actually put it in writing.
Right. This is for the original plan for the stunt we filmed on June 20th.
That's right. Your studio was contractually obligated to tell Peter to pull.
That's right, and that's exactly what we did for all 7 takes.
And you're telling us in court today that you told him to pull on June 21st.
Yes, at 9 seconds, I gave Peter Jones the signal.
Well, sir, I want to talk about whether or not we should believe you. Sir, you said you were a producer. What you didn't tell the jury on direct examination is you own Dragon Studios, right?
That's right, I'm the founder.
You're the founder and owner.
Yes, that's correct.
That's a multi-billion-dollar production company.
Yes, it is.
That job's your whole life.
I guess so.
That company is how you make your money.
It is.
And you care a lot about your company's reputation.
I care a lot about my company, the actors, the crew that work with us.
Sir, one of your actors died on your company's watch, right?
He did.
It wasn't just your company's watch. He died under your watch, didn't he?
He did. I pulled the signal, but I just don't know what happened.
And now you're in court because your company has had a claim brought against them, right?
That's right.
A claim brought against them for being negligent.
That's what I'm told.
A claim brought against you for causing Peter Jones's death.
That's what they said.
Well, sir, I want to talk about who could tell us whether or not you told him to pull. You weren't out on that cliffside with Peter Jones, right?
No, sir, I was in the control room.
That's right. You were in that control room with one other person.
His agent.
That's Eli Gogion.
That's right.
So Miss Gogion and you were in that control room alone.
Yes, it was just she and I.
You were standing here with the radio.
Yes.
She was about 5 feet this way, by your side.
Give or take, she was in the room with me.
And you're claiming that you said pull.
I did.
You're claiming you screamed it.
Several times.
But sir, that hasn't always been your story, has it?
I'm not sure when you mean.
Well, sir, after Peter Jones hit the ground that day, you went down, right?
Yes. After the accident, Eli and I took a helicopter to the field.
That's right. You went to check on Peter Jones's body.
That's right.
Sir, unlike when you were in that control room, you weren't alone, were you?
No, sir.
It wasn't just one person beside you that day, was it?
No, it was the crew as well.
Sir, the whole crew was there.
That's right.
Miss Veglahn confronted you, didn't she?
She started asking a couple of questions.
Sorry, she yelled at you.
She did.
She asked you, why didn't you tell him to pull?
That's what she said.
So let's talk about what you said. So you didn't tell Miss Veglahn, oh, I did. Did you?
No, she asked me why I didn't call it 9 seconds, and at that point, Peter had just died. I didn't know what else to say.
So you didn't say, oh, that earphone, it might have malfunctioned.
Didn't say anything.
Well, sir, actually, what you said was I just wanted a longer shot, right?
When she asked me why I waited longer, I told her I wanted the scene. When she asked why I didn't call it at 9 seconds, I didn't know what else to say. I was still processing.
So, sir, when she asked why you didn't tell him to pull, you didn't say you did.
She asked me why I waited so long, and I told her why, and it was because we wanted the scene to be longer.
You're only telling that to these members of the jury now.
I also told Eli on the night of that I wanted the scene to be longer.
Sir, I'm just asking if you told him you pulled. You didn't say that.
No, I didn't then.
Thank you, sir. Your Honor, I have nothing further.
Thank you, counsel. Redirect.
No redirect, Your Honor. We just ask that Mr. Doig be excused.
He is excused. Thank you, Mr. Doig, for your testimony.
Thank you.
With that, the defense rests our case in chief. We're ready to move to closing arguments if the plaintiff is.
Okay, we'll take a 1-minute recess. And then
Yes, sir.
Then we'll move to closing argument. Okay, jurors, are you ready to proceed? All right. Seeing 4 nodding heads, we'll move to closing argument, first from the plaintiff.
Yes, Your Honor. With the court's permission?
Go ahead.
Your Honor. Ms. Veglahn. Members of the jury. This is a case about trust. We put our trust in different people every single day. When Ms. Veglahn and I walked into court today, we put our trust in Judge Bishop to preside over this case fairly. And now, we're going to put our trust in you. We trusted you to evaluate this case based on the facts. And on June 21st, Peter Jones put his trust in his director. But we're here because that director broke that trust. We're here because Peter Jones waited for a word that never came. And members of the jury, that's what makes this case so terrible. Because at some point, when Peter Jones was falling through the air, he must have wondered, why hasn't anything been said? As he's getting closer and closer to the ground, he must have imagined at some point that ground was getting too close. He was going too fast and he was going to die. why did his director say nothing? Members of the jury, that wasn't a question you had to wonder about. In fact, it's something the defendant was wide open about. In fact, when Peter Jones's body was still warm on the ground, he told Miss Veglahn, as both he and Miss Veglahn told you on the stand today, I just wanted a longer shot. Members of the jury, we can talk a lot about what risks were assumed, and we will. But Peter Jones could never have imagined his director would put all Law 7 over his safety. I mean, Ms. Veglahn said this a lot today. This is a question about whether or not he assumed the risks of a 9-second plan, but members of the jury, that only matters if that plan was followed. And you heard it wasn't. I mean, think about the 3 facts we told you about at the beginning of today's trial. So we're going to go through the facts, then the law. And let's start with the facts. Peter Jones's director made a promise. That 9-second plan wasn't just to let 9 seconds pass. That plan was to give the word at 9 seconds so he could pull. They talked about industry standards and about how that was unsafe, but that director told Peter Jones, 1,000 feet will be fine. 9 seconds will be fine. They keep talking about margin for error, but they keep ignoring the fact that an error must have been made. Don't let them do that, members of the jury. You can't have it both ways. Either he assumed a risk and there was a risk, or the plan was fine. So what was the risk? Because the defense certainly didn't give you an answer. But we did. Miss Veglahn did. That's fact too. Peter Jones was never told to pull. He did that stunt 6 times, and every single time he pulled, what changed? The word. The word that never came. As members of the jury, you heard Miss Veglahn say, that word was never given. And sure, maybe, just maybe, if this was in a vacuum, that would be a he said, she said, but in this case, it's just not. Because Peter Jones's actions speak louder than Mr. Deutsch's words ever could. Why wouldn't he pull? That's it, members of the jury. Why? I mean, what are they asking you to believe? He had a death wish? No, members of the jury, he didn't pull because he wasn't told to. He relied on that director. That director broke his trust, broke that contract, and killed him. And that takes us to fact 3. That is the risk that caused his death. Members of the jury, facts are difficult things. They're hard to get around. Because there was a risk in this case. But if that plan is margin for error, what's the error? And they can't ignore that. Because they didn't show you an error that happened, we did. The risk that killed Peter Jones was the fact that that word never came. Members of the jury, the law is simple. You're going to be answering one question at the end of today's trial. Did Peter Jones assume the risk that killed him? Key words. The risk that killed him, and members of the jury, we showed you that risk was the fact that director stayed silent and he waited for a word that never came. Fine Dragon Studios Live. Thank you for your time.
Thank you, counsel. Defense, are you ready for your closing argument?
Yes, Your Honor.
Go ahead.
Mr. Parker-Noblitt. Members of the jury, may it please the court. When Peter Jones jumped, he knew he could fall. Just a second ago, Mr. Parker-Noblitt asked you a question. He said, what was the risk? He told you that we didn't give you an answer this trial. I want to take just a moment before we get into the facts to talk about the assumption of risk, about what it is and why it's important. Because members of the jury, when we talk about a margin for error, when we talk about an unsafe jump, I want to be really clear about what this stunt was. Peter Jones was agreeing to drive a motorcycle at top speed off of a 2,700-foot cliff. He was agreeing to let go of that motorcycle in midair and fall. He was agreeing to rely on one person, on one earbud, to give him the signal to open his parachute. And when he agreed to change that stunt from 4 seconds to 9, he was agreeing to the fact that there would be no time to fix any error. He was agreeing to the fact that if something went wrong, he could die. And that matters. Because as the defense, we came into trial today with a burden of proof. To prove to you by what's called a preponderance of the evidence, just that it's more likely than not that Peter Jones understood the risk he was taking. And he did it anyway. It's a burden we've met today. And to show you how we did it, I want to go back to the 3 simple facts I mentioned at the start of this trial. The 9-second stunt was dangerous. Peter Jones knew it, and he jumped anyway. So first, the 9-second jump was dangerous, and I apologize to bring this all back to numbers, but there is one number that is really important. 2,000 feet. 2,000 feet above the ground, industry standard for a safe jump. That is important. Because when Peter Jones agreed that 2,000 feet above the air was the low, safe minimum every second that he waited, every foot he agreed he would pull his parachute closer to the ground. 4, 5, 6, 7, 8, 9. He was allowing that margin for error to get smaller and smaller. He was agreeing that that jump would be riskier and riskier, and he knew that when he jumped. That's fact number 2. Peter Jones knew how dangerous that stunt was. How do we know? It is on this contract, in ink, in his handwriting. This says, I know what the industry standard is. This document included these calculations. He knew when he agreed to that 9-second jump that it was going to be a whole lot more dangerous. Members of the jury, when Peter Jones signed this contract, he told each and every one of you that he understood the risk of what he was doing, and that he understood the risk of throwing that plan off the cliff ahead of him. Fact number 3. He jumped anyway, and he died as a result. Folks, whether you believe the plaintiff's witness, that Cole Doig never gave that signal, whether you believe Mr. Doig that he absolutely did, whether you believe there was some technical malfunction, or Peter Jones just couldn't reach the cord, or he couldn't hear over the wind, it doesn't matter. Whatever happened up there at the 9-second mark doesn't matter. When you consider what Peter Jones was willing to do. He was willing to jump. He was willing to drive a motorcycle off a 2,700-foot cliff. He was willing to let his plan and his practice and his ability to save himself fall to the ground with his motorcycle. As Peter Jones watched the ground get closer and closer on June 21st, he had already assumed the risk. Folks, he had already jumped. And he was already falling. Fine for the defense. Thank you.
Thank you, counsel. Rebuttal?
Yes, Your Honor. Quick time check.
You have 19 seconds for rebuttal.
With the court's permission.
Go ahead.
We keep talking about margin for error. What's the error that killed him? I mean, Ms. Veglann's right. There is a number that matters in that case. This number is 0. That's the amount of words, the amount of warnings that director gave and members of the jury. It would have taken 1 syllable, 1 word. He didn't get it. Find them liable.
Thank you, counsel. The matter is submitted. We're off the record. And congratulations to both of you. That was excellent. Great job. Before we move to some very brief feedback, I just want to make sure that all of the ballots have been submitted. So if you could just give me a quick thumbs up if you've submitted your ballot. Great, great, great. Once I see that all the ballots are in, then we can talk a little bit about your